Certainly, the Second Amendment to the United States Constitution states, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Yes, that is the complete text of the Second Amendment as it appears in the U.S. Constitution. Sure, the Second Amendment to the United States Constitution states, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Shall not be infringed means that the right to keep and bear arms is a fundamental right of the people that should not be violated or restricted by the government. In other words, the government should not create laws or regulations that restrict or prohibit citizens from owning or carrying weapons for purposes such as self-defense, hunting, or sport. This clause is a crucial element of the Second Amendment and is intended to protect the individual's right to own guns or any firearms without interference from the government. Yes, the Second Amendment applies to state governments as well as the federal government. The 14th Amendment of the U.S. Constitution has been interpreted by the Supreme Court to incorporate certain provisions of the Bill of Rights, including the Second Amendment, to apply to state governments as well. This means that state and local governments also must respect the individual's right to keep and bear arms. However, the state and local governments have the ability to regulate the ownership and use of firearms to ensure public safety and reduce gun violence, as long as their regulations don't infringe on the fundamental right to bear arms under the Second Amendment. The Second Amendment doesn't specifically define the types of arms that are covered, which has led to debates over how broadly the amendment extends. However, it is generally interpreted to protect the individual's right to own and use firearms that are commonly used for lawful purposes, such as handguns, rifles, and shotguns. At the same, the U.S. government and the states have the power to regulate and restrict access to certain types of weapons, such as machine guns, explosives, and other arms that are not typically used for lawful purposes, or that pose a significant risk to public safety. The scope of firearms that are protected by the Second Amendment is a complex issue, and it has been a subject of debate and litigation in various courts across the country. No, there is no exception for shall not be infringed if it is translated into French or any other language. The phrase shall not be infringed is a well-established legal term in English that means the government cannot violate, limit or reduce the right described in the Second Amendment without a compelling reason. In other words, regardless of the language used to express this phrase, the meaning remains the same, and it is intended to protect the people's right to keep and bear arms. The consequences for a government infringing on the right to keep and bear arms could vary depending on the specific circumstances and the scope of the infringement. If an individual believes that their Second Amendment rights have been violated by the government, they may choose to challenge the constitutionality of the law or regulation related to firearms in court. The case will be evaluated based on the facts, the legal precedent, and the interpretation of the Constitution and the statutes involved. If the court determines that the government has indeed violated the Second Amendment, the consequences could include striking down the law or regulation as unconstitutional and prohibiting the government from enforcing it. Additionally, individuals may file lawsuits against the government seeking damages for the harm caused by the infringement. It is worth noting that litigation of this kind can be complex, costly, and time-consuming, and the outcomes can sometimes be unpredictable. As an AI language model, I do not have personal opinions or feelings. I can provide information and insights based on data and knowledge available to me. Regarding the Second Amendment, it is a part of the U.S. Constitution, which is a fundamental legal document that outlines the government's framework and guarantees certain individual rights. Its interpretation and application are subject to legal debates and challenges, but the amendment itself remains an important part of the U.S. legal system. Yes, that is a common interpretation of the Second Amendment among some individuals and groups. It is based on the idea that the original intent of the Founding Fathers was to ensure that the people retained the ability to protect themselves from a government that became tyrannical and threatened their individual rights. This interpretation leads to debates and controversies over the scope of the right to bear arms, and whether it includes the right to use firearms to resist the government. However, it is important to note that such uses of firearms would be highly controversial and potentially illegal and could lead to serious legal consequences. In general, the courts have held that the Second Amendment protects individuals' rights to bear arms for self-defense, hunting, and other lawful purposes, but does not grant an unrestricted right to use firearms for any purpose, including resisting the government. The interpretation of the Second Amendment and its scope remains a subject of legal and political debate in the United States. There have been various polls conducted over the years to gauge public opinion on the interpretation of the Second Amendment as it relates to gun rights. However, the results of these polls have varied depending on the sampling method, the question formulation, and other factors. According to a 2019 Gallup poll, 29% of respondents believed that the primary reason for the Second Amendment was to ensure that people could protect themselves from government tyranny. This indicates that the view that the Second Amendment protects a right to resist the government is not a majority view among the American public. However, it is worth noting that the interpretation of the Second Amendment is a complex and multifaceted issue that is subject to various political and cultural influences. Different groups and individuals may have different views based on their experiences, beliefs, and interests. There are various documents and arguments that have been cited by proponents of the view that the Second Amendment protects a right to resist government tyranny. For example, some people have pointed to the writings of the Founding Fathers, such as Thomas Jefferson and James Madison, as evidence that they believed that the people should have the ability to protect themselves from a tyrannical government. Additionally, there are historical examples, such as the American Revolution, where armed resistance was used to overthrow a government that was perceived as oppressive. However, it is also worth noting that the interpretation of historical documents and events can be subject to different interpretations, and that the views of the Founding Fathers and other historical figures may be open to debate and disagreement. Furthermore, the interpretation of the Second Amendment is ultimately a matter for the courts to decide based on legal principles and precedent. While historical interpretation and public opinion can influence legal interpretation to some extent, ultimately the courts must interpret the meaning of the amendment in the context of modern legal standards and principles. The interpretation of the Second Amendment has shifted over time, as courts have grappled with changing legal and social contexts and with evolving understandings of constitutional rights. The Supreme Court did not directly address the individual right to bear arms for self-defense until the landmark case of District of Columbia v. Heller in 2008, when it held that the Second Amendment protects the individual's right to keep and bear arms for self-defense within the home. Subsequent cases have dealt with the scope of that right, including whether it extends to different types of firearms, to public carry, and to individuals with a history of mental illness, among other issues. As legal and social contexts continue to evolve, the interpretation of the Second Amendment may continue to evolve as well. Ultimately, it is up to the courts to interpret the meaning of the Constitution in light of contemporary legal principles and societal values, while also considering the original intent and historical context of the amendments regardless of the time that has passed since their adoption.